Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today, I am so pleased to have uh, Piero David Learti, and if I mispronounced it,
That
please,
was perfect, Michael.
okay, please.
I know
And
it's challenging from a US perspective. We say Pierodavide in Italian, but I know
here,
it's challenging from.
and so Piero Davide is an intellectual property attorney based in Milan, Italy. Welcome. Uh,
Thank you, Michael.
Why don't you tell us a little bit about yourself, your firm, what you do?
Absolutely, with pleasure. So, Michael, thank you very much for having me. It's really a pleasure to be here and to meet you again. So, my firm, as we said, is based in Milano, and which is, as you will all know, it's the business capital of Italy, and so we have a lot of work here. And I do specialize in intellectual property advice. I am an admitted attorney at law at the Milan bar. And I focus entirely on advising my clients on each and every intellectual property asset that they may have, namely trademarks, design, that we do not call design patents because they are treated differently than in the US. Patents, invention patents, of course, trade secrets, and copyright. So what I do as an attorney at law, I represent my clients basically in all transactions regarding intellectual property assets, including their development or, as we mentioned before, restructuring their IP portfolios. I advise them on drafting contracts and legal opinions concerning validity and enforceability of IP rights. And then we do filing for trademarks and designs, which we will discuss it later, are very easily managed at the European Union level. So that's mainly my field of activity.
Sounds like a heck of a lot.
Yeah, it is.
And so, I mean, you mentioned that the designs are different than the US. So, can you tell the audience about the relationship between designs, how it differs from the US, and how it differs from trademarks?
Absolutely.
Or is it closer to patents or trademarks? If you can just elaborate a little bit on that.
Sure. I don't want to get into details of the US design patents protection because it's not my field, but
Right.
for the experience that we had together, we have a very unique protection for designs, namely the shape, what we consider being the shape of a product or a part of a product. For us, if this part of a product can meet the validity requirements that are generally novelty and originality, as we call it, then we can be more precise on that. The holder of the IP right can obtain a registered certificate that will guarantee protection for 25 years from the date of filing for the entire European Union. And what is amazing of this kind of protection is that the registration is generally granted with only the examination of formalities, and the substantive examination is generally not made. And the registration and renewal fees are incredibly low as compared, for example, to trademarks and invention patents. So with this type of protection, which has been very recently renewed from a legal point of view, because there was a huge reform that went into place in 2025, this year. Companies can access an incredible level of protection for the design of goods, packages, etc. And this will allow them, for example, seeking protection from copycats from China and to activate, for example, custom surveillance programs. And this will ease incredibly licensing products, for example, with distributors. And also from a contractual point of view, you can easily sell those registrations instead of relying on non-registered design. I don't know if that was sufficiently clear from.
Yeah, we don't want to get too much into the weeds
Okay.
here, but
Okay. Just to give you a rough idea.
Yeah. I mean,
what is incredible, and then we can talk about that also in terms of trademark protection, is how easy it is to get this registration that cover, as I said, the entire EU market is incredible. Because we have a tool that allows us to file an application with very simply made design, 7 views of the same object.
Okay, so yeah, I don't want to just
Okay.
focus solely on the design part.
Okay. Yeah, sure. Okay.
Yeah, so you talk about the EU. I mean, let's get into the trademark component
Sure.
here.
Sure.
Uh, I mean, you're filing one trademark application. Does it cover the entire EU? Does it what's relationship with Great Britain? What about the non-EU uh, countries in Europe? And is there a way to just get extra protection, or do you have to file separately? If you can go a little bit of an overview on how to
Absolutely.
manage a trademark application slash portfolio in Europe.
Absolutely. With pleasure. So also for the first off, we had Brexit. So the United Kingdom is no longer part of the EU. So when we had the European Union trademark that covered also the UK, what happened with the old EU trademarks was that when Brexit was effective, the UK government granted a separate and identical UK trademark registration coming out of the original EU trademark registration. But as of today, when you are filing something at the EU level, this does not cover the United Kingdom anymore. For what concerns the EU, what we have is one single European Union trademark application and registration that covers with one application and registration the entire European Union.
Which is how many countries? What, 27 countries?
27.
Yeah, okay. Right.
So this does not substitute each and every national trademark application and registration, is something different. So there is one registration that covers the entire EU, which is incredibly practical because the registration fees, are very low. For example, first class of product is 850 euros per 10 years. The second class is 50 euros, and from the third class onwards is 150 euros. So as you can see, the registration fees are incredibly competitive. And also, what is fantastic in my professional experience about managing trademarks at European Union level is that the EWIPO is incredibly efficient in terms of internal work. So applications can be managed very smoothly. Each time you have to respond an office action, it can be done very easily. And also recordals, for example, of transfers, changing the names, changing the representatives, all that stuff that may add up costs during the life and management of a trademark can be done very easily. And so for a client, this is incredibly useful because it cuts costs. And
I
for
mean,
us,
yeah. Do you have to show use?
you
know,
don't
and does it have to be in all the countries, one of the countries? Like, how does you can go into a little bit about that?
Yeah, as compared to the US, we have a totally different system. Trademarks are open to non-use cancellation actions if they haven't been used for 5 years. And but you don't need, as it happens in the US, to submit proof of use on some occasions. So what happens is that if you don't use a trademark, the trademark can still be renewed. And if no one lodges a cancellation action, you can still keep on using the trademark. I'm oversimplifying, of course. You can keep on using and keep your registration. So the office is not asking for proof of use. Only a third interested party can file a cancellation action due to non-use.
And so if you have use in one country, does it count for use in all the countries?
No, exactly. That is a very good question.
Okay.
And so basically, you have to prove use in each and every EU country, even if there was some case law stating that you can show use in most of the countries, provided that you can cluster all those countries together. So, but again, in my personal opinion, non-use, in my personal experience, non-use cancellation actions are incredibly rare. And but again, that is something that must be taken into account, because if needed, you need to prove use for each and every EU country.
Is there also a country by country registration system?
Absolutely. As I mentioned before, the EU trademark system did not cancel the national trademark systems and legislations. For example, we have the Italian trademark law, which is now together with an intellectual property code that covers all intellectual property rights. And they are still in place. And for example, you can have both an EU trademark registration and then Italian, French, German trademark registrations. Generally, IP legislations are harmonized because we are all part of WIPOs, and so of the Marrakesh, and also because of the EU directives. So generally, EU trademarks legislation and national trademark legislation are very close.
Okay. All right. Well, thank you, Pierodavide.
Wonderful.
And thank you for all of you out there. Hopefully you'll tune into the next episode of Unraveling Intellectual Property with Michael Stein. Why don't you give a little plug? What's the name of your firm, and what is your contact information?
My firm is named after myself, so it's Studio Leardi, Intellectual Property Management. I am based in Milano, in Via Fontana 22, Milano downtown, and my contact information is leardi@leardi.it. If you want me to spell it, it's leardi@leardi.it.
All right. Well, thank you.
Thank you.
For everyone, thank you for tuning in, as I said, and look forward to seeing you on our next episode, or as I usually say, till next time.